Good morning, convening our Committee on Public Safety. Today is March 25th, 2026, 10 a.m. We are in conference room 411. Members, we have a number of bills that are coming back towards us that we've already heard. So hopefully this can be done expeditiously. First up, we have Senate Bill 3294, House Draft 1. This is our wrongful imprisonment bill. We have comments from Judiciary.
Good morning, Chair, Vice Chair, members of the committee. My name is Jennifer Owong. I'm the staff attorney for the criminal divisions of the First Circuit Court as well as for Judiciary Administration. The Judiciary provided some comments on the legislation. We do have some concerns operationally with respect to how we would be able to implement these provisions in the case types that these original rulings would be made. Specifically, if it was remanded from the appellate court, then the decision to dismiss the case would be made by the criminal court. And if it's in a Rule 40 proceeding, then Rule 40 is limited in terms of the types of rulings they can make, and they cannot rule on any civil nature type things. So ultimately what would have to happen is we would have to be able to transfer this somehow into a, as I described in the last paragraph, into a civil proceeding so that the proper parties could be served, and so that we could issue those proper orders to, say, DCR, to the Attorney General, or to the Department of Human Services, and or the comptroller to make those partial payments. So we do have some issues with respect to that. I will say that we have been in communication with the Attorney General's office, and we are speaking with them with respect to how we can try and make this bill operationally workable for us, and I'm hoping to work with them, if not by the end of the session, then definitely in the interim, in order to proceed with this bill.
Okay, great, thank you. We have testimony in support from the Department of Corrections and Rehabilitations. Director.
Thank you. Good morning, Chair, Vice Chair, members of the committee. I'll just summarize my testimony real quick. We just have concerns with page 5, section 2, and page 8. In short, once the person's released, we have no jurisdiction in the case, so it should be DHS that just assigns a case manager to the person. We'll alert DHS as the law as this requires, but DHS should assign the case manager. And then, of course, we will work with the person on the ID card issue.
Okay, thank you, Director. Testimony in support, Office of Public Defender. Testimony, comments, Department of Human Services.
Good morning, Chair, and Vice Chairs. This is Edie Mae Shiro. I'm representing DHS. We stand on our testimony written that we have submitted.
Okay, thank you, Edie.
Thank you.
Okay, we have testimony in opposition from prosecuting attorney for City and County of Honolulu. Testimony in person, Community Alliance and Prisons.
Good morning, committee. Kat Brady testifying in strong support of this measure. You know, 38 states have similar laws, but Hawaii's law as it stands now is one of the strictest. So we really believe it was overdue. I know that the chair worked really hard on this bill collaboratively with agencies and the community, and I can't express my appreciation for that strong enough. We know Alvin Jardine, Ian Schweitzer, Roy's Durrell, and Gordon Cordero spent decades in prison. Well, Royce 8.5 years, but the other three anywhere between 23 years and 30 years. It's ridiculous. And no statute could actually ever restore those decades. But the state can decide whether to compound the injury with procedural resistance. We really hope you pass this bill. Thank you so much.
Thank you. We have testimony in support, Law Office of Setsuko Regina Gromley, in person or on Zoom. Seeing none, we have testimony and support from a number of individuals. Sarah Cordero, Zoom. Gordon Cordero, Zoom.
Here.
Go ahead, Mr. Cordero.
Good morning. My name is Gordon Cordero. Thank you for having me. I was released on February 21st, 2025 after being wrongfully imprisoned for 31 years. When I was exonerated, the Department of Public Safety gave me a 30-day supply of medication, walked me to the gate, opened it, and left me there. No plan, no support, just gate closing behind me and a world I was expected to navigate completely on my own. I was lucky. My family was there. They brought me clothes. They gave me a place to stay. They gave me a phone. They gave me a ride. Without them, where would I have slept? They helped me apply for medical coverage and food assistance. They took me to get an ID. They gave me a starting point. Without them, I would have been free and completely abandoned. No ID, no money, no transportation, no access to basic necessities, no guidance on where to begin. This is not just my story. We have already seen what happens when an innocent person is released without support. It leads to homelessness, instability, and in some cases, tragedy. That's why this bill is necessary. The advance payments are not a windfall. They are not a reward. They are basic survival. Temporary support, like $5,000 a month, means the difference between stability and homelessness. It allows someone to secure housing, buy food, access transportation, and begin rebuilding their life. The state spends tens of thousands of dollars each year to incarcerate a person. When that person is innocent, we should not hesitate to invest in helping them recover from the harm that was done. This bill must also restore critical legal protections, ensuring that accepting state compensation does not force an innocent person to give up their right to seek justice through the courts. Those are constitutional rights and they must be preserved. It must also restore medical coverage and benefits continuity, not just for the individual, but for their families, because wrongful incarceration does not just impact one person, it affects spouses, children, entire households. Families lose income, stability, and access to care, and when their loved ones and finally come home, they're all trying to recover together. No one walks out of prison and immediately into stability. There is always a gap, a period of rebuilding. Without support, that gap becomes a crisis. Freedom without support is not justice, it's neglect. When a state takes 31 years from an innocent person, it takes birthdays, families, and futures that can never be returned. And when that person is finally proven innocent, the state cannot simply open a gate and walk away. If we know this happens and we choose not to fix it, then we are not delivering justice, we're continuing the harm. No innocent person should have to stand at the gate wondering how they will survive. Pass this bill. Take responsibility and make sure that when state finally does the right thing, it doesn't stop at opening the gate. It helps people walk through and truly live again. Thank you for your time, and I hope you pass this bill. It's very important.
Thank you, Mr. Cordero, and thank you for continuing to track this measure for future folks.
Thank you.
Really
Thank you for
important.
continuing to move it on. I
Thank you.
appreciate it.
Okay. Mr. Will Carone in support, Paul Bernstein in support, Douglas Hagan in support, John Kawamoto, Barbara Polk, Carolyn Ito, Denise Cordero, Noel Morin, and Sam Mitchell, all in support. Any other testifiers in the room? Any other testifiers on Zoom? Seeing none, members, questions?
Question, Chair.
Go ahead, Representative Shimizu.
Jennifer. I'm trying to thank you, Jennifer, for being here. I'm trying to understand your testimony, and are you saying that according to this bill, the judiciary is flagging some concerns, but it is doable, or there are some things that need to be corrected in the bill in order for it to be implemented? I'm not sure.
Yeah, so thank you for the question. Essentially, when a case is either vacated, when a conviction is either vacated or and then the case is dismissed, that all happens in a criminal context. It either happens in a Rule 40 proceeding, or if the appellate court is the one that vacated the conviction, then it gets remanded down to the criminal case. And the criminal court will then determine whether or not the case is going to be dismissed or not, or if it's gonna go for a new trial. those criminal courts have very limited jurisdiction in terms of what we can do. We are basically prosecuting defendants. In civil courts, you can have equitable relief, so you can order payments to people, you can do all of the things that are in this bill. So in essence, it has to be transferred to a civil court in order to make all these payments ordered and direct like DHS to appoint a case manager, to direct the Department of Corrections and Rehabilitation to inform us how long the defendant has actually been in custody. They are not a party to the criminal case, so we don't actually have any authority to order them to do anything, or order the comptroller to pay $5,000 a month. Because they're not a party to the criminal case, we don't have the authority to make those orders. We would have to transfer it to civil, and we would have to serve those entities. Most of them are represented by the state, so we could serve the Attorney General's office. But we would have to create a new case, serve the proper parties, and then be able to have authority over them to order them to do the things that are in the bill.
So you're just pointing out the complexities of the process then, but it is doable, or are you suggesting something that could be done better in the bill to make it better?
I'm hesitant as the judiciary to draft legislation due to the separation of powers. So I can't exactly answer that specifically, but I can tell you operationally how we would need it in order to effectuate the intent of the legislature, which is for the judiciary to order specific entities to do specific things.
So you're not able to provide specific amendments then, is that what you just said?
I mean, I can say that we are going to have to transfer it into a civil matter. So much like the other provisions of 661B, which require a petition to be filed in the circuit court, that is a civil case. This particular bill creates a new provision of 661B that seems to require the judiciary to do all of this in a criminal context, which I'm not clear can be done. We would have to transfer it into a civil type case, such as the 661B, I believe it's 3 petition area. Similar, we'd have to do something similar to that. So it's already in the bill, it's just, it's already in statute. We would just have to be able to make it clear to the legislature that the things that you're asking us to order in this new provision could not technically be done in the criminal case or in a Rule 40 proceeding. We would have to transfer it into a civil proceeding, which is already contemplated by the rest of 661B.
So it is doable, it's just a lot of bells and whistles and so forth.
Moving parts, yes.
Okay.
You know, essentially, there's a 5-day
Okay.
requirement in this new subsection, which would be difficult for us to, because the way the bill is written right now, it appears that the judiciary is required to basically create this petition for the former defendant, now petitioner. And in order for us to do that, we would have to file a petition on their behalf somehow, and then serve the appropriate entities on their behalf somehow.
Okay, I'll yield and hand it off to my colleague.
Any other questions?
I think, I think that what can happen is that the Attorney General can hear your concerns and then work with the Judiciary Chair to amend as it keeps moving the language that will implement,
Yes.
so that it's not the judiciary making law.
Right.
I'll just do a quick follow-up. So on that issue of the 5 days, to me, this is a mechanical question. So if we extend it to 10 days with the idea, because service and all that, it just takes time. That's just the nature of like the filing of a petition.
Yeah.
It's like a 10-day window. Would
Yes.
that be something that would be more doable?
For us, for the judiciary, for us to file it and serve the appropriate entities in order for us to issue the orders that you're asking us to issue, yes, the 10 days would be much more palatable than.
Right, because
5
it
days.
could like fall on a Friday and then you have a holiday and then so what we're doing is we're making sure all the bureaucratic milestones are met.
Yes,
Okay. And then at the end of the day, we actually want the court to order this.
correct. And
Because then it holds the Attorney General accountable.
right, and I understand that as well. There is a little provision in the bill currently that requires the judiciary to determine the amount of days that the defendant has been in custody as one of the preliminary findings. I would just like to point out that that's not necessarily something that we would have in either a Rule 40 or a criminal court case. That's something that we would have to ask the
DCR
DCR for, which is another thing that we would probably prefer to transfer to the civil so that they can order DCR to provide us with that information. And they will provide us with that information, it's just, we don't have it in the criminal case or the Rule 40 case,
Okay.
because they're not a party to the action.
Okay, I wanna follow up one other thing in your testimony. The parallel cases on same issues occurring under Rule 40 versus HRPP Rule 40, the other. So penal procedures, yeah. Can that be resolved somehow?
So the thing I'm pointing out there is that even if a Rule 40 court were to make the rulings that are being asked for, that it's consistent with innocence and that they were held in custody, there is a right to appeal in a Rule 40. In Mr. Cordero's case, the Maui Prosecutor's Office is appealing the Rule 40 decision. So that case is currently on appeal. We lose jurisdiction at that point to make any further orders. So the concern is that if we were required by this bill to then transfer some things over to civil, we would have a Rule 40 proceeding that is going up through the appellate courts on that ruling. And then we would also be going forward in a civil case as to whether or not any relief is going to be granted due to the vacation of the conviction in the Rule 40 proceeding. So, I mean, technically, Mr. Cordero's case has not been dismissed yet, his underlying criminal case. So it's kind of, he's in that situation where we could end up with parallel things. I don't know how that would come out, and I cannot comment on how that would come out if
Yeah.
it went to the appellate court.
Have you seen that kind of bifurcation occurring in other states with this kind of
I have not.
statutory framework?
And I would be happy to hear anybody's position on that.
Okay, maybe that's something we take up with actually the advocates, because that's becoming clear what the problem is. Okay, thank you. Go ahead. Go ahead.
So has this been done before as far as what is already currently in law and wrongful imprisonment, reimbursements and so forth?
You mean here in Hawaii?
Yeah.
So I only know of the 4 cases that we have been discussing throughout the legislative session. I know that 2 of the cases were settled and it is part of the AG's package requesting payment for those settlements. And the other 2, again, Mr. Cordero's case, his actual criminal case is still pending because the whole Rule 40 thing is still going up through appeal. In the Schweitzer's case, I believe that their actual, I'm sorry?
No, go ahead.
No, I believe that their actual case is still with the civil court on the Big Island.
So
So
what you
it hasn't-
described in your testimony is playing out right now then?
Yeah, in Mr. Cordero's case, certainly it is, yes.
Thank you, Chair.
Any other questions? I have a question for Director. Is this, I appreciate your amendments, is this worked out with Department of Human Services? Just to make sure that the lines, the clarity of,
I didn't contact them, that's my fault. I'll contact the director and let him know.
okay. All right, thank you for this and for pointing out that we lost this element in the transfer of the case or of the bill. Is DHS still there?
Yes,
Okay, quick question on yours. Have you been able to see the testimony by Director?
yes,
Does that clarify and make clear what DHS's responsibilities will be?
and I understand that, but we need some time to go through and how exactly it would work. And if you read our testimony too, there's things that we're already doing with DCR with our 1115 and things like that. So I understand, but I think there still needs to be more conversation and collaboration.
Okay, on the issue, hold on the issue of advanced compensation that would affect the the person's eligibility under Medicaid, are you aware that of course settlements can be structured so as to preserve? So that's
Yes.
not really a non-issue, that's a non-issue.
So in some of our programs, we don't even look at assets, and so it's a case by case. And we were discussing ways to work around this, but yes, I understand that.
Okay, great. And I really appreciate the work that you folks are doing on an 1115 waiver. As the work on that progresses, will the operationalizing of this kind of movement of individuals be easier?
So it's a different kind of thing, because I feel like, the ones that are released because they were, incorrectly, put in prison, we would always look at them and help them when they get out. What we're doing also now for those that are actually in there, doing the 90-day pre-release, all the things that we're working on trying to implement, those are helping people that are there now and also to do a smooth transition. It would assist anybody who's already in there, and part of this group could be part of those people. So all the work we're already doing with DHS is facilitating, helping, the justice involved individuals.
Good, thank you. I mean, I think this is really important, like as you folks make progress, and I know Department, DCR and DHS are working hard on making sure that the 1115 waiver gets executed upon. I just, the overlapping nature of that work with helping individuals who are subject to wrongful imprisonment, the overlap is there, it's just there.
There's overlap, yes.
So thank you very much, and thank you for being here on behalf of the Director, Edie.
Very welcome.
All right, any other questions? All right, seeing none, let's move on to the next bill. We are at Senate Bill 2614. Thank you, Director. This is our authorizing DOE to award a high school diploma to a qualified person who did not receive a high school diploma as a result of compulsory or voluntary induction into the armed services of the United States, or whose high school education was interrupted due to wartime practices during World War II, the Korean War, or the Vietnam War. Hopefully this is an easier bill. First up, we have testimony and support from the U.S. Defense State Liaison Office. Testimony and support from Hawaii Office of Veterans Services. Testimony and support in person from Department of Education.
Aloha, Chair, Vice Chair, members of the committee. Elizabeth Higashi on behalf of the Department of Education. We are here to testify in support of this measure, and we are asking for an respectfully asking for an immediate effective date as the department is ready to implement upon approval. Thank you.
Thank you. Good news. Testimony and support from Hawaii Military Affairs Council. Testimony and support from VFW Department of Hawaii. Any other testifiers in the room? Any other testifiers via Zoom? Members, questions? Okay, seeing none, moving on to Senate Bill 3118. This is relating to the Interstate Compact on Education Opportunity for Military Children, updates references to the US Code. We have testimony first in support from US Defense State Liaison Office. Testimony in person in support from Hawaii Department of Education.
Hi, Chair, Vice Chair, members of the committee. Elizabeth Higashi again from the Department of Education. We stand in our testimony and support, again respectfully asking for an immediate effective date upon approval, as this is just a housekeeping measure in regards to our military interstate compact. Thank you.
Thank you. Testimony and support from Military and Communication Relations Office. Any other testifiers in the room? Any other testifiers on Zoom? Seeing none. Members, moving on to our last bill, Senate Bill 3156. Relating to federal military installations, authorizing the Department of Transportation to enter into agreements with the U.S. Department of Defense. First up, we have in support the Department of Transportation.
Morning, Chair, Vice Chair. Kurt Otaguro, Deputy Director for Airports, Department of Transportation. Department stands on its written testimony of support. Happy to answer any questions. As you know, this is a very important initiative for us. And we hope that the committee will give favorable consideration. Thank you.
Thank you. Wonderful to see you, Mr. Otaguro. We have testimony in support from Military and Communications Relations Office. Testimony in support, Hawaii Emergency Management Agency. Testimony in support, Hawaii Military Affairs Council. Testimony in support from individual Mike Golu Sr. Any other testifiers in the room? Any other testifiers via Zoom? Seeing none, members' questions? Okay, members, let's, we're gonna recess for decision making. Likely we will be moving out all of these measures. Testifiers, you don't have to stick around if you don't want to. I'm gonna move this to our next agenda, which is set at 11 AM, I believe. Our next agenda is 11 AM.
Yes.
So we will pick this up and do DM at 11 AM. Members, any questions? All right, see y'all at 11 AM. We are in recess. Good morning, reconvening our 10 AM agenda for Wednesday, March 25th, 2026, conference room 411. This is the Committee on Public Safety, taking up measures on our 10 AM agenda. Members first. On Senate Bill 3294 relating to wrongful imprisonment, Chair's recommendation is going to be to adopt the amendments from DCCR. Any tech amendments identified by HMSO for clarity, style, or consistency. This measure, I believe, already has a defective date, so let me make sure. Yes, we'll keep that same defective date. Members, comments, questions, or concerns?
Yes, Chair, did you want to do the extended 10 days?
No, I think for that, thank you for reminding me. I think we understand the problem more. The 5 days is there. This is something that can go to conference. That number can always flex if we get more information from the department, as well as DCR or the judiciary.
Okay.
Go ahead, Vice Chair, for the vote.
Okay, voting on SB 3294, SD2 HD1. Chair's recommendation is to pass with amendments. Let's see, sorry. Chair and Vice Chair vote aye. Representative Hashem? Aye. Representative Ichiyama?
Aye.
Representative Mariwakawa?
Aye.
Representative Poi Poi?
Aye.
Representative Woodson?
Aye.
Representative Shimizu?
Aye.
Representative Souza?
Aye.
Chair, your recommendation is adopted.
Thank you. Moving on to Senate Bill 2614, House Draft 1 relating to education. Again, members, we've seen this bill, I think, 2 years in a row, possibly 3. Chair's recommendation is to move this with a effective upon approval date. We have gotten been in communications with Chair Woodson and the back end chairs, so we're going to move this with a effective date. Comments, questions, or concerns? Seeing none, Vice Chair for the vote.
Voting on SB 2614 HD1, Chair's recommendation is to pass with amendments. Noting that all are present, are there any members wishing to vote no? Any members wishing to vote with reservations? Seeing none, Chair, your recommendation is adopted.
Great. Members, moving on to Senate Bill 3118, House Draft 1 relating to the Interstate Compact on Educational Opportunity for Military Children. Again, Chair's recommendation is to put an effective upon approval date for this. Again, we've had clearance from the other committee chairs. Questions, comments, or concerns? Seeing none, Vice Chair for the vote.
Voting on SB 3118 SD1 HD1, Chair's recommendation is to pass with amendments. Noting that all are present, are there any members wishing to vote no? With reservations? Seeing none, Chair, your recommendation is adopted.
Thank you, members. Senate Bill 3156 HD1. Chair's recommendation is to pass unamended. This has an HD1 on it, so it's got a defective date and it will go on to move to finance. Questions, comments, or concerns?
Sorry, I just want to clarify, it's pass as is, I'm sorry.
Pass is.
Pass
As is,
as
unamended, yeah.
Chair, I'll be voting with reservations only for the reasons I stated on the House bill version, which is that from my understanding, they can currently engage in this work, and my concerns are using state resources to build the federal facilities when we often find ourselves having so much shortage in so many areas. Anyway, that's all. So
Okay.
with reservations.
All right, thank you, Vice Chair. Any other comments, questions, or concerns? Seeing none, Vice Chair for the vote.
Okay, voting on SB 3156 SD1 HD1, Chair's recommendation is to pass as is. Noting that all members are present, are there any members wishing to vote no? And any reservations other than my own?
Reservations.
Okay. Thank you, Chair, your recommendation is adopted.
Thank you. So we are adjourning our 10 AM agenda, opening up our Wednesday, March 25th, 2026, 11 AM notice of decision-making agenda. Members, Chair's recommendation is going to defer this for further decision-making until Friday on our 11 AM agenda. Members, we have a 10 AM agenda on that day as well for concurrent resolutions.
This Friday, right? This Friday.
Yes, I know it's a recess, but we're still working, right? It's a legislative recess day, but it's still a work day,
It's work day.
right? It is still a work day.
Absolutely.
I know it's not, I know we're not happy about that, members, but. Well, again, we have to vote no on a legislative day. It is also, members, it is also a deadline. It is a second lateral deadline.
Are we gonna DM at 11 on everything?
Yes. We'll DM everything, yes. Everything will be DM'd on that day. Okay, yeah, we will, okay,
The resolution talking.
we will make sure, we'll work to make sure we have quorum, whatever is the case. All right, I know, members, it's been a trying last 2 weeks for all of our communities. So Chair's recommendation is to move this to DM at 11 AM on Friday, March 27th, 2026, this room, conference room 411. Thank you, members, thank you for your hard
Oh
work.
wait, what about the last one? Did we? There's one more.
Both, I'm gonna
Oh.
defer both
Oh,
for
sorry.
DM, defer both Senate Bill 2109 and Senate Bill 2151. Thank you, members, we're adjourned.
Thank you, Madam Chair.